as well as our attendees today in my role as the NBA's Government Procurement Law Section Vice Chair. The National Bar Association is the nation's oldest and largest national association of predominantly African-American lawyers, judges, educators, and law students. The NBA has 84 affiliate chapters throughout the United States, and we have affiliations in Canada, the UK, Africa, and in the Caribbean. The NBA represents a professional network of more than 60,000 lawyers, judges, educators, and law students around the world. The NBA's Government Procurement Law section is the newest section within the NBA. It was founded in March 2019 by the current section chair, Ms. Kendra Perkins Norwood, with the support of many others in the NBA community who recognized the need for a section devoted to promoting the professional development of legal practitioners engaged in the practice of government procurement law, consistent with the objectives of the NBA. Today's topic is an important one. It is a timely one, and it is an urgent one. And so on behalf of the section, I would like to thank each of our speakers in advance for the information and insight that they will provide today. However, before I turn it over to Mr. Robert Drummer, a distinguished member of the NBA and of our section, I have a few brief announcements I'd like to share on behalf of our chair, Kendra, regarding the section's upcoming activities. First, and very relevant to the topic today, our section is in the process of developing formal comments on the provisions of the Executive Order 13950 for submission to the U.S. Department of Labor's Office of Federal Contracts Compliance Programs. Comments are due on Tuesday, December 1st, and anyone interested in contributing to the comments should contact Robert Drummer at rgdrummer@law.gwu.edu for additional details. The section is also planning a pipeline event entitled Career Pathways and Other Opportunities in Government Contracting for Future Attorneys of Color. This event is tentatively planned for the January-February 2001 timeframe. If you're interested in participating, please send an email to the section's email account, nbagovprolaw@gmail.com. If you're interested in participating as a speaker, we're looking for in-house counsel, outside counsel, government attorneys, judges, suspension and debarment officials, and others whose practices relate to government contracts and procurement. We're also seeking event sponsors, so please stay tuned for additional details. And finally, if you're interested in joining our section, we encourage you to do so. We're a new and a growing section with lots of opportunities to get involved. And you can join us by going to the National Bar Association website page and searching the membership page for our information. So without further ado, I'll turn this over to Mr. Drummer. Thank you very much.
Thank you, Madam Vice Chair. And I echo her welcome to each of you for taking time out of your schedules today to join this very timely and highly sensitive and controversial topic. If my slides can get brought up. As those are coming up, if you're going to advance, first I'd have to give as a government employee the normal disclaimer that the views and opinions expressed during this presentation by myself are those solely in my personal capacity and do not represent the U.S. government, the Department of Education, nor the Office of Federal Student Aid. Next slide, please. Here's a roadmap for today's program. First of all, for those of you who may want to claim CLE credits, there will be a couple of code words embedded throughout the webinar that you will need to write down. And at the conclusion of the webinar, submit those code words to receive your certificate of participation today. First, we'll begin with the introduction of the panelists, who will then provide first an overview of the executive order and how did we get here, what advocacy efforts that have taken place to date, as well as what advocacy efforts we expect in the future. And third, the impact of the executive order on the federal government contracting communities. We'll allow times for questions and answers. And then we'll lastly finish up with recommendations and next steps to include what Vice Chair Craig mentioned. First, the response to for information in the comment period provided under the executive order, as well as communicating with the Biden-Harris transition team, as well as other advocacy campaigns. Next slide, please. So just by way of citation, prior to the executive order, the Office of Management and Budget Director provided a letter and a memorandum to the public on September the 4th, alluding to the inevitable executive order that was issued on September 22nd. Next slide, please. And on September 22nd, that executive order was issued, and here are some of the citations and references to retrieve the executive order if you don't have it already. Next slide. Starting with my self-introduction, as Vice Chair Craig alluded to, I serve as Chair of the Membership Committee for the Government Procurement Law section. I have some experience in the civilian federal sector with the Department of Education, Federal Student Aid as a senior acquisitions attorney, and over 20 years in the U.S. Army Reserves JAG Corps, a lot of which was spent on government contracts, and currently pursuing an LLM in government procurement from GW Law School. I would be remiss if anecdotally I didn't reference along this list my affinity for my beloved fraternity, Omega Psi Phi. We celebrated our Founders Day this past week. And so on a webinar discussing diversity and inclusion, as well as in the backdrop of Vice President-elect Harris being both an HBCU and a Pan-Hellenic member, I take a bit of moderator privilege in highlighting that. But enough of me. I know enough about government contracts to be dangerous. Fortunately, we have some real subject matter experts to delve into this topic today. Next slide. Starting with our first presenter, Ms. Shirley Wilcher. She's currently the Executive Director of the American Associations for Access, Equity, and Diversity. As importantly, she's a former Deputy Assistant Secretary at the Office of Federal Contract Compliance Programs during the Clinton administration. So she can provide us not only a thorough analysis of the executive order, but also the kind of the inside baseball analysis that goes into the policy rationale for even putting together an executive order. She's an honors graduate of Mount Holyoke College. She earned her MA in New School for Social Research, and she holds her JD from Harvard Law School, as well as she's a certified affirmative action professional. Next slide. Our next speaker is Ms. Janai Nelson, who's the Associate Director and Counsel for the NAACP Legal Defense Fund. She served as lead counsel on various high-profile litigation cases, such as the Vesey v. Abbott federal challenge to the Texas Voting Rights Act, voting ID law. She's testified before Congress on voter suppression and other civil rights issues. And she's also served as in academia at St. John's University School of Law. She earned her BA from New York University and her JD from UCLA School of Law. Next slide, please. And our third panelist is Darius B. Withers, who is the legal lead counsel for the South Region North America Accenture, LLP. In this capacity, Darius has a wide portfolio of public service and government contract technology issues, but at both the federal as well as the state and local levels. So he brings a girth of background and intellect and experience in that space. His other prior experiences include private practice as well as U.S. federal service at the Federal Communications Commission, and he earned his BA from the University of Virginia and his JD from the George Washington University Law School. With that, please help me welcome our panelists, and we will begin with Madam Deputy Assistant Secretary Wilcher.
Thank you, and thank you for the invitation to speak to you today. It's been a long time since I've worked with the National Bar. I am aging myself, but yes, I have been around since in the 1980s, when I worked on Capitol Hill for Augustus Hawkins, and Clarence Thomas was the chair of the EEOC, during which time we, of course, gave him a pretty hard time for his tenure there. But I'm very grateful to be invited here. There's a lot to share, so I'm going to share my screen to get started. Very good. Now I'm kind of new to Zoom, so please bear with me. Now, again, the executive order was signed on September 22nd, 2020, purporting to promote economy and efficiency in federal contracting and to promote unity in the federal workforce and to combat offensive regarding America's race and sex stereotyping and scapegoating. It prohibits contractors and subcontractors from, because I can't see that, from using any workforce training that inculcates in its employees any form of race or sex stereotyping or any form of race or sex scapegoating. And Section 1 of the order attempts to recount America's civil rights history. By the way, I understand Stephen Miller drafted this. That's the pretty good rumor. So that would be understandable. In Section 1, the order attempts to recount America's civil rights history from the bus boycott in Montgomery and the Selma to Montgomery marches, and quotes the Declaration of Independence. Juxtaposed against this history lesson, the order goes on to argue that a new ideology has emerged, rooted in the pernicious and false belief that America is an irredeemably racist and sexist country, and that some people, simply on account of their race and sex, are oppressors. The order sees recent analyses of histories as attacks on white men, and asserts that views that acknowledging the pervasiveness of racism are divisive. Now, I understand this all started when a gentleman by the name of Christopher Rufo spoke on Hannity's Fox News show, and I guess the president saw it. And from there, Mr. Rufo has some issues in an ongoing campaign against critical race theory. And so it reached the White House, and this is the result. The executive order talks about some issues that happened at Treasury, where there was a seminar that promoted arguments that virtually all white people, regardless of how woke they are, contribute to racism, and that instructed small group leaders to encourage employees to avoid narratives that Americans should be colorblind or let people's skills or personalities what differentiates them. It also cites an issue that happened at Argonne National Labs, stating that racism is interwoven into every fabric of America, and it describes statements like color blindness and the meritocracy as actions of bias. In order to fix the problem reportedly emerging from the 1619 Project and presumed trainers of critical race theory, in one broad stroke, this order strikes at the heart of the movement toward diversity and inclusion in the American workplace. Let me state that the statement that I'm citing is from our own organization, the American Association for Access, Equity, and Diversity. I should add that AAED was founded in 1974 as the American Association for Affirmative Action, and that our members are the EEO and affirmative action, and increasingly the diversity individuals who are responsible for compliance and doing investigations on college and university campuses, in private industry and in government. So we feel very strongly and have some really strong views about this order. To go on, the Trump order urges executive departments and agencies, the uniformed services, federal contractors, and federal grant recipients to continue to foster environments devoid of hostility, grounded in race, sex, etc. So this order really paints with a pretty broad brush and covers just about every aspect of federal, not only contracting, but grant making. So it is very broad and probably reaches every college and universities, all federal contractors, and the federal government. The order goes on to attack what it calls blame-focused diversity training or stereotyping as reinforcing bias and decreasing opportunities for minorities. You can read the order, but I'm just highlighting some of its content. The definition of divisiveness rejects the argument that embedded in concepts of meritocracy in, for example, employment or admissions are privileges based on race or class. So it rejects the whole notion of white privilege. And also the notion or the teaching of unconscious bias. So it really goes beyond the letter of the order, reaching trainings now that really get to the reasons why we deal with systemic racism, not only in the workplace, but in life in general. It attacks the whole notion that there really isn't a meritocracy, at least some would argue, because of its groundings in race and racism. So the order mandates that it shall be the policy of the United States not to promote race or sex stereotyping. But what concerned us at the association is that the order says federal contractors will not be permitted to inculcate such views in their employees. We have some serious issues with that. And calling attention to the nation's history of slavery and its vestiges apparently would be a violation. Now, the effective dates of the order was effective immediately through the enforcement of 11246. Although the requirement for insertion in federal contracts takes effect November the 21st, i.e. tomorrow. Again, so that the executive order is effective for contractors entered into after November the 21st. However, the Office of Federal Contract Compliance Programs at the Department of Labor is also inferring in the existing executive order that it enforces, inferring the authority to review based on its non-discrimination mandate to review diversity and inclusion programs even today. So in a statement that our association issued, we say instead of efficiency, the order flies in the face of the First Amendment and burdens federal agencies with the role of a content review board. It also promulgates a particular worldview about American history and seeks to enforce such a view in the education and training programs of government agencies. The timeline also, we believe, runs the risk of violating the Administrative Procedure Act and the Paperwork Reduction Act, which require notice and comment before applicable rules are implemented. I should add that when I was the Deputy Assistant Secretary, the employer community was very much on me and our administration, very concerned about making sure that we complied with the letter of the APA and the Paperwork Reduction Act. I personally asked the director of OFCCP, Mr. Craig Lean, were they in compliance in the PRA, with the PRA, and I never received a response. We believe also the order overburdens the federal agencies, including OFCCP, which is understaffed and overloaded with the responsibilities it currently has. Let me say that they enforce Executive Order 11246, and I'll talk about that briefly. And as an agency that covers federal contractors, the agency covers roughly 1/4 of the civilian labor force. Now, when I was at OFCCP, we had a high of 815 FTEs. Now the OFCCP has less than 500 to cover 1/4 of the civilian labor force. So also I should add, if someone complains about the content of a diversity training program, OFCCP will have to force the contractor to submit its curriculum and related materials for approval. We understand that the OFCCP has already received more than 100 complaints and inquiries that it must investigate. Now, as I mentioned, OFCCP enforces President Johnson's 1965 Executive Order 11246 on equal opportunity, affirmative action, and non-discrimination. In my view, they don't have the time to oversee any diversity and inclusion programs or issues of unconscious bias. And let me say, these are new concepts and are not included in 11246, again, signed in 1965. I was at OFCCP when the whole diversity movement and discipline was developed. And it was developed by private industry and also by colleges and universities who wanted to delink themselves from the enforcement requirements of the government. Affirmative action was considered compliance. Diversity and in later inclusion were terms that that private industry and higher ed owned that were delinked from the requirements of 11246. Now, we also note that consistent in the Trump order, contractors cannot use any training that inculcates race or sex stereotyping, and they must notify unions of the requirements to combat race and sex stereotyping. And that requirement has to be included in every contract. Contractors who violated the Trump order risk losing their contracts through procedures enforced by OFCCP. Now, let me say that during my administration, there was a handful of actual debarments. Yes, there would be some kind of conciliation agreement if they did find a problem. The likelihood of actual debarment, which is the most extreme and drastic sanction, is remote. But you don't want the hassle of even going through that, which is why ultimately we will call for the rescission. As you know, the order also requires OFCCP to establish a hotline to investigate complaints within 30 days. They have created that hotline, and I mentioned that there have been calls and inquiries exceeding 100. Now, they issued a request for information. I understand the deadline is December 1st. And so that's what's ongoing now. I want to underscore that the request for information is voluntary. Now, I should mention also under Section 7, OMB and the Office of Personnel Management are required to review all training programs for agency employees. That is so extraordinary. Both agencies have to approve the content of training programs. If a contractor providing diversity training includes the prohibited language, it risks being debarred from obtaining contracts with the federal government. So I suspect they're going to do a keyword search. And if you have this prohibited language, you as the contractor providing the training risk being debarred. But it's not enough that the agencies will do this oversight. The order requires the Attorney General and the EEOC to assess the extent to which workplace training that teaches these divisive concepts may contribute to a hostile work environment and give rise to potential liability under Title VI. So again, this order reaches not only grantees or contractors, but anybody covered by Title VII. And that is also the way the OFCCP is justifying doing regular compliance reviews with an eye towards looking at 13950, looking at diversity and inclusion programs as possibly creating a hostile environment under 11246. It's again, what are these divisive concepts? The question, the definitions are not actually clear. Now, there is this exception when it comes to educational programs. It's fine if it's, done in an objective manner and without endorsement. We don't know though if colleges and universities teach, history or teach, use the concepts of unconscious bias, whether that's viewed as objective. Again, I think probably most of you know the mission of OFCCP, but in this PowerPoint, I don't make assumptions. And when you take a look, if you get a copy of this, and I believe we are going to distribute it, it provides for a summary of the requirements of the executive order program of OFCCP. Again, OFCCP receives complaints, but it also, and most of its work involves compliance evaluations. They schedule compliance evaluations, a certain number every year. How do you get scheduled? Or if you work for a contractor, there is a quote unquote neutral, it is pretty, I gather, still neutral selection process. But when they schedule you for a compliance evaluation, they can go on site. They can also request, if you've got 50 or more employees in a contract of 50,000, your written affirmative action program. But in addition to that, as a part of the compliance evaluations, I hear they can request a copy of your D&I training materials. Let me underscore that. In addition to making sure you have no adverse impact, that you have affirmative action goals, which the executive order requires, now they're saying, let me see your D&I training. And I'm understanding that this administration is using the regulations permission to do focused reviews, which we did during my administration. We added that to the regs. They're using focused reviews to focus on diversity and inclusion programs under 11246. So be mindful of the expansion of 13950 as interpreted within the context of the existing executive order. As I said, OFCCP may investigate claims of race and sex stereotyping under 11246. They have FAQs on its website, and it asserts that stereotyping is unlawful, as I said, under both executive order. And take a look at those FAQs, because they say training is not prohibited if it's designed to inform workers or foster discussion about preconceptions, opinions, or stereotypes. But the question is, where is the line drawn? And as I said, using the hotline, individuals can file a complaint. OFCCP will investigate complaints as it does normally through the normal process, where it's you can download a complaint form, the agency will investigate. Note that third parties may also file a complaint on behalf of an individual or group. As it says, complaints received under the authority of 11246 will be investigated immediately following the agency's standard procedures. And as I said before, 11246 becomes effective in federal contracts. But again, if you're already covered, already have a contract, they'll invoke 11246. And I'm just leaving the link for the hotline. What are the implications of this order? As I said, We have heard that, and it's been reported to us that D&I trainings and trainers have lost contracts and their programs are being discontinued. I should add that my own association does diversity management training. Guess how many people actually paid for the training this time? 0. So this has had an impact on our own program. And we're a small organization, so our training overall is essentially half of our annual budget. So it's having a chilling effect, either directly on contractors or indirectly on trainers being paid by contractors to do diversity and inclusion training. Now, you've probably read that Microsoft and Wells Fargo received a friendly letter from OFCCP when their senior officials indicated that they plan to hire more minorities. This is part and parcel of this new advocacy effort. I don't remember writing a letter about this kind of thing unless there was clearly discrimination. If there's a major lawsuit, we might have gone in and done a review to make sure there was no discrimination. But to out of the blue send a letter to major companies saying, when they say, consistent with what's happened after George Floyd was murdered, we're gonna up our game and hire more people of color, to send a letter questioning their commitments and urging them not to use quotas. Again, more chilling effect. Now, one thing I should add though, any company, again, delinking diversity from their affirmative action in EEO offices and coming up with their own goals for hiring are asking for trouble. They really need to work with their affirmative action EEO people because affirmative action goals are required by law, by the executive order. Diversity is a new construct. It is not necessarily grounded in law. So if you come up with your own numbers and you pull them out of the air, and they're not linked with the Executive Order 11246 or consistent with Title VII's permission to do voluntary affirmative action, you are asking for trouble. Now, next steps. We're urging the Biden administration to immediately rescind 13950. Otherwise, the agency will have to continue enforcing the order, excuse me, unless instructed not to. We're also recommending that the Biden White House takes action on the order and not wait until the Secretary of Labor or the Director of OFCCP is in place. When I was brought on board in '94, more than a year after President Clinton was elected. That's because the position is not, it's not secretary level, and you have to get the labor secretary who has a role in selecting the director of OFCCP and the sub, cabinet level staff. We're going to urge them to really step it up so, we don't have to wait for a year before we have a director of OFCCP. But again, the White House needs to take action on this because the longer, they take, the more damage can be done. I should also say that we support the litigation filed by LDF and Lambda Legal to halt the enforcement of the order until it can be properly rescinded. Also, let me underscore that opponents of this order include such disparate organizations as the American Council on Education and the U.S. Chamber of Commerce. Now, we don't often get this community of people on both sides of the spectrum when it comes to equal employment opportunity and enforcement. The last time I remember, actually there were two other times. The first was during my first job working with Gus Hawkins on education and labor, when the Reagan people tried to weaken, if not kill, 11246 back in, well, I'm dating myself. I'm just gonna say 1985. Yes, I'm old. I'm older than most of you probably, but that was my first job, save 11246. That's the rare time when employers, conservative employer groups and the civil rights community came together and we're doing it again. And hopefully that will be impressive to this new administration. We also urge you, our general counsel put together some defensive actions you might be mindful of, but this is by no means legal advice. You need to be on the alert for required language in new contracts, prepare talking points for employee questions, and be prepared to respond to complaints. If you have some diversity training and some person decides who is being asked to participate in the training says, well, I'm going to complain to the Labor Department because you use the words unconscious bias, you're going to have to be prepared to deal with that. Review training content, and I am so sorry that anyone would have to go through this exercise, but consider your own defense if you work for a contractor or even a grant recipient. By all means, however, do not stop conducting EEO-AA in your diversity and inclusion training. We must consider it. With that, I say thank you. Thank you for the opportunity. And I'm happy to answer any questions.
Well, thank you, Madam Deputy Assistant Secretary. We will now turn to Ms. Janai Nelson with the NAACP Legal Defense Fund who will talk about the various advocacy efforts by that community of stakeholders that the Deputy Assistant Secretary just mentioned. Ms. Nelson?
Hi, hello everyone. Thank you so much. I am going to try to share my screen so that you may see some slides, and much of it covers what Ms. Wilcher already began to describe about EO 13950. And let me just start by saying I'm very delighted to be part of this panel. Let me confirm that my screen is being shared. Can someone give me a nod? Okay, good. So let me thank you for inviting me to represent the Legal Defense Fund. My name is Janai Nelson, the Associate Director Counsel of the Legal Defense Fund. And I am so grateful that the NBA has put on this panel, that the section on government procurement saw fit to highlight this executive order. We were quite alarmed when it was first issued, and there seemed to be a very delayed reaction to the import of this executive order. Many people initially thought that it was focused only on trainers who spoke specifically to the issue of critical race theory, or that if they simply amended their training materials slightly, they could dodge this bullet. I think Ms. Wilcher already laid out why that is absolutely the wrong conclusion to come to when you read this order. It is broad, it is vast, it is vague, it is targeted, and it has a very clear agenda, and that is to stamp out any discussion of racial reckoning, any truth concerning the history of racism and systemic racism in particular in this country, and to limit progress on gender equality. So when the Legal Defense Fund first saw this executive order, we knew that legal action was necessary, and we began to work on a challenge. There was a lot of question about whether this was necessary in light of the forthcoming election. And I want to say that while we do expect a new administration, a Biden administration, to rescind this order because it is so deeply offensive to civil rights and to racial progress, it is still doing a lot of damage right now. And we still have a fair amount of time between today's date and January 20th for it to continue to have the impact that it is having on trainings in workplaces throughout the country. And it is also important that we meet this executive order with a forceful rebuke to show that this is not the type of infringement on free speech that can be countenanced by any democracy. And that is why we continue to pursue this legal action despite the outcome of the election. And as we know, there are ongoing challenges even there. So that is the preface for our concern about this executive order. So what I hope to do during the time that I have with you is to talk a little bit more about the executive order and provide a bit more detail about some of the specific provisions, to tell you about the lawsuit that we filed, as well as some of the statements by not only the Legal Defense Fund and other civil rights organizations, but the general backlash that has thankfully been generated against this executive order, as well as a very progressive public education campaign in response to the order that we hope will endure and in fact be a wonderful silver lining to this very offensive assault on equality. So let's start with the executive order. It was issued, as you know, on September 22nd, and it's already been noted that it is quite deceptive in its stated intent. It does not combat race and sex stereotyping. In fact, it promotes a very singular view of this country's history of racism and gender equality. The key focus of the order is how this particular term, divisive concepts, is defined. And upon reading the executive order, this term jumped out at me as such a concerning way to describe thoughts and theories that have been widely accepted and used to combat racism and sexism in our country. Just the idea that there are such things as divisive concepts that can be stamped out or prohibited really smacked of a totalitarian effort by this administration. And we wanted to call that out. I think it's important to walk through what is defined as a divisive concept to understand the breadth of the order and exactly what potential ramifications it can have. So first, it speaks to the idea that one race or sex is inherently superior to another race or sex. Clearly, that's a principle that anyone can theoretically get behind. The concern, though, is how they might interpret that particular divisive concept as they've defined it. They have prohibited any notion that the United States is fundamentally racist or sexist. So to say that the United States was founded and built on the backs of slaves, for example, that it has at its core inherent racial inequality, that the founding fathers were racist or sexist. In theory, all of those concepts, true as they are, would be prohibited and considered divisive under the executive order, as would any concept that suggests that an individual, by virtue of his race or her sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. So as Ms. Wilcher mentioned, this targets unconscious bias, implicit bias, which have been key tools to expand our thinking about equal protection and equality in the workplace, that you don't need to necessarily intend to cause racial discrimination or operate with racial animus, but that there is often unconscious or implicit bias that motivates actions in the workplace and can lead to discrimination. This particular provision suggests that any concept along those lines would be prohibited. It also says that an individual should be discriminated against or receive adverse treatment solely because of his or her race, that members of one race or sex cannot and should not attempt to treat others without respect to race or sex. That is a direct assault on the idea of colorblindness, not assault, it is a direct promotion of the idea of colorblindness, which we know based on what we've seen happen over the years, starting with Prop 209 in California, and many other efforts to, erase race in this country, is a way in which our civil rights laws are deeply impacted and defanged, frankly, because you cannot use race to correct racial discrimination. And we know Chief Justice Roberts has subscribed to that idea, and this is a reinforcement of that concept. And a likely outcome, as has been mentioned, is that any effort to diversify leadership or workforce may be attacked in this through this provision, as well as any affirmative action programs. There's a great concern that this idea of color blindness will halt and, in fact, impede and retard the efforts that have been made over many decades to try to remedy race and gender discrimination in the workplace. And in fact, it goes directly against Title VII law, which is something that we raise in our complaint, where you do need to take account of someone's race to understand what a hostile work environment might be and whether certain comments or statements or actions give rise to the creation of a Title VII claim. The other divisive concepts that are prohibited are the ideas that moral character is determined by race or sex, that someone bears responsibility for acts committed by members of the same race. So effectively banning any idea that there is white privilege or there is a commonality of racism or sexism in this country. I think most concerning is this provision number 8, which says that any individual should feel discomfort, guilt, anguish, or any other form of psychological distress on account of his or her race or sex. So not only is that oddly worded and vague, but it is such an incredibly subjective term and phrase that it can be interpreted in almost any possible way to critique training that makes someone feel uncomfortable. And I've never seen such a subjective analysis that is not tied to any specific action that is already acknowledged as a violation of one's civil rights or constitutional freedoms. And then finally, the idea that meritocracy or traits such as hard work ethic or are racist or sexist or created by a particular race, that is a very targeted response to a training that this administration learned of, in which the concept of meritocracy was being challenged and deconstructed. And as you know, if you think about the way in which we talk about affirmative action and the idea of what constitutes merit, which is often in a very narrow concept in higher education and in other contexts, this would prohibit that type of challenge to concepts and restrictions on access and opportunity for so many in our society. So if you take this constellation of terms together, contrary to what many thought at the beginning, it is very hard to imagine how you can engage in an effective training on diversity, how you can engage in creating an open workplace, how you can educate your workforce on issues of racism and sexism without running afoul of Executive Order 13950. So that is why we thought the challenge was absolutely necessary, and that there was an urgency to moving forward. As we've noted, there's some key words that are being used to signal whether a training is particularly concerning or may violate the executive order. Phrases like critical race theory, white privilege, intersectionality, systemic racism, positionality, racial humility, and unconscious bias are all target words. And again, many believe that if they simply do a word search and scrub their materials for these terms, that they will somehow, dance between the raindrops of this executive order. But I will say that I don't think that that is a sufficient response to this executive order, because it is the concept. It is anything that you would explain or define that would fit within these ideas. That is what is prohibited, not just these key words. But this is a real tell in terms of what this executive order is meant to combat. And in our view, it is meant to center the privilege of white male cisgender persons who don't want to have to confront this country's history and ongoing manifestations of racism and sexism. So these are the key terms that give you some inkling about, again, its breadth. So this brings us to the complaint that we filed in the District Court of Columbia, the District of Columbia. We filed suit on behalf of two stalwart civil rights organizations that we are honored to represent, the National Urban League and the National Fair Housing Alliance. These are two organizations that have had federal contracts and that also have at the core of their mission racial equality and obviously also support gender equality in the workplace. They were as dismayed as we were about this executive order and wanted to challenge the order, and not just on behalf of themselves and their institutions, but as class representatives of all federal contractors and all recipients of federal grants. That is the framing of the lawsuit that we've brought. So the relief that we seek, if satisfied, would benefit all persons and entities that may be affected by this executive order. We sued Donald Trump, we sued Eugene Scalia, the US Secretary of Labor, and the US Department of Labor. And we essentially brought three claims. The first is a First Amendment violation based on viewpoint discrimination because of all of the reasons I explained earlier, that the specific concepts and ideas that are prohibited based on the executive order represent particular viewpoints with which this administration clearly disagrees and has based its executive order on a particular worldview and outlook that it wants to give primacy to the disadvantage of other concepts and thoughts that we believe are just as valid, if not more. So this is a classic First Amendment challenge based on viewpoint discrimination, and we know that there are restrictions on the government limiting First Amendment freedoms based on the content of thoughts and ideas. The second claim that we made was based on the vagueness of the order, and I think you could see from some of the passages that I described that it is very vaguely worded in a number of areas. And the Fifth Amendment of the Constitution holds that a federal law is unconstitutionally vague if it fails to provide a person of ordinary intelligence fair notice of what is prohibited, or so standardless that it authorizes or encourages seriously discriminatory enforcement. And that results in a due process violation. How do you know whether you are running afoul of the law if it is written so vaguely that it's hard to discern what its application might be? And that is the argument that we're making under that claim, that Executive Order 13950 is so vague that it's unclear for anyone who is not only engaged in training around diversity, equity, and inclusion, but simply, trying to, as I said earlier, educate a workforce or create a culture of inclusion and understanding in the workplace. It's unclear whether their efforts might run afoul of Executive Order 13950, and therefore their due process rights might be violated. The third and final claim is rooted in the equal protection component of the Fifth Amendment's due process clause, which guarantees all persons the equal protection of the laws and prohibits the government from treating persons differently on the basis of race, religion, national origin, or alienage than, similarly situated individuals. And many factors in this order point to race and sex-based discriminatory motive. I encourage you to take a look at the complaint that we filed. It actually outlines how the how the executive order came to be. Ms. Wilcher mentioned Chris Rufo. He not only identified certain trainings that he found concerning, he went on some conservative news networks and actually demanded that an executive order be issued. And lo and behold, the executive order came out not too far after, which should not only be concerning because we're legislating from networks, from conservative networks, but the motivation behind it was quite clear. And in much of the commentary, including the very preamble of this executive order, we see what the actual focus is and what the racially discriminatory motive seems to be. We've talked some about the chilling effect, and I'm glad that Ms. Wilcher highlighted the idea that there may be an exception for academic institutions, but noted how challenging it might be to actually understand what it means to teach these subjects in an objective manner. And so I wanted to highlight that the chilling effect has been extreme, not just for those entities that engage in diversity training and feel most directly targeted by it, but even academic institutions like Stanford University just earlier this week have now circumscribed their trainings and workshops in response to this executive order and did so preemptively. It's deeply concerning to us that Stanford thought that it needed to take this step this soon, this early, and did not push back against the potential application of this. But this gives you an example of how institutions are trying to cover themselves in response to this executive order. So the idea that there can't be any reference to structural or systemic racism on a college campus in a training or workshop or program should be deeply alarming to anyone who cares about academic freedom or just First Amendment protections more broadly. So this is an example of what I believe is an overcorrection in response to the executive order. And we sadly are seeing this in many spheres and are noting this chilling effect. Let me move on to what some of the advocacy has been as I begin to wrap up. Our organization, along with the Lawyers Committee for Civil Rights Under Law, the National Women's Law Center, and the Leadership Conference for Civil and Human Rights, drafted a statement condemning the order and calling for its immediate rescission. It was signed by over 120 organizations, and we continue to use this as an advocacy tool. And I should note that there have been well over 36 letters of this sort by other entities, including from the US Chamber of Commerce, including from a wide variety of institutions and coalitions that have sought rescission of this executive order and have roundly condemned it. So there is a very vocal, outside of the litigation that was filed, there is still a very vocal cohort of advocates against this executive order. We've also paired with the African American Policy Forum to launch a public education campaign called Truth Be Told. And this campaign is meant not only to bring more awareness to this executive order, but in fact to use that as a platform to command a more robust and more deeply engaged conversation about racism and sexism in this country. So what the executive order seeks to silence, Truth Be Told seeks to uplift and center and vocalize. And we expect that this is a campaign that will endure beyond the effect of the order and will provide an opportunity to hopefully reverse the damage that the order has already caused and may continue to cause while it is in effect, and return us to a more clear reckoning with our history and with the current demons of racism and sexism in our society. So you can learn more by going to the African American Policy Forum's website, Truth Be Told. The Legal Defense Fund also has a page on our website that can give you more information about this executive order, that has a link to our complaint and has other resources for you. And if you know of an organization or entity that is being affected by the executive order, we're also collecting narratives through the Truth Be Told campaign about the impact of this executive order, which is very important for us to be able to trace and track. So I look forward to entertaining your questions during the Q&A. Thank you.
Thank you, Ms. Nelson. And before we go to our final panelist, Mr. Withers, who will discuss the impacts on the federal contracting community where the rubber really meets the road, the code word and code phrase, for those of you who may want CLE, the first code word, code phrase is Biden-Harris. Again, the code phrase is Biden-Harris. Now, with Mr. Withers, please share with us, how is the federal contracting community responding to this executive order?
Happy to do so, Robert, and really appreciate the perspectives that my fellow panelists have brought forth, because I think they very much provide a foundation for the reality that contractors are facing on the ground. I will tell you that if I had to summarize with an acronym, since we are talking about federal contracting, I call it a triple C, which is it is continuing, it is chilling, and it's costly. That is how federal contractors are seeing this. I really want to emphasize that. This has both impacts from a standpoint of human rights, social justice, but it also has an impact both on contractor activities, costs, efficiencies, and ultimately, if you think about this in the context that this order asks for significant changes, scaling, modification, you start to wonder, relevant issue. I mean, this is violative of the Anti-Deficiency Act. How is any contractor going to effectively take trainings? And these, again, often these trainings may be internal to the government contractor itself, but the very fact that they are engaged in that training and they have to do that within the letter of the law, whether that's Title VII specifically, the failure to do that, every contract, whether it's at the state or the federal level, has a compliance with laws provision in it. It can become a significant element of any negotiation. This creates an actual risk of debarment, or at least, particularly with the existing administration, investigation or audit. There have been questions unanswered at this point whether DCCA will take it upon their agenda to start doing searching examinations of contractors. So I'll bring that as a broad perspective. Again, costly, chilling, and continuing. And the continuing is important. There was a question that one of our members asked, very legitimate question. As a first impression, you might ask, isn't this all going to become moot once President Biden, Vice President Harris are in office? And they have it allegedly on the top 10 list of items that they intend to rescind, within the first 10 days. Nonetheless, as Ms. Wilcher mentioned, right, government it moves, but it moves at a particular pace. People who are in this administration, the current administration, which will be in place for at least another 61 days, those individuals are already being identified as dropping into the GS service and moving out of accepted service. The other reality is that to put in new people, having myself, again, different experience, but aging myself, right? Second term of Clinton administration coming to Federal Communications Commission, probably we're looking at, and that was a quote unquote friendly transition. That was first term to second term. You still had people come, it still took approximately, let's call it 6 months under good conditions from the time of inauguration, or for that matter, even election, to you actually started to see people get their sea legs. So you're probably talking about not actually seeing new people in place with appropriate, small p political power in their agency and the particular entities we've talked about from changing practices until this time next year. Or let's just say new federal government fiscal year. So let's give them the benefit of October 1, 2021. So people are sitting in seats, have fully staffed structures, and this assumes you've got a Senate that allows for appropriate, appointments without delay. That being said, the government contractor community sees that and recognizes that they're going to have to be dealing with this for at least the next year. The chilling element for a government contractor is that this very discussion, what Ms. Nelson talked about, what Ms. Wilcher talked about so eloquently, is true in terms of creating an environment. And I think in many ways, I'm gonna make this point, I think very much reflects a deliberate effort to, you might say, poison the well. We're going to see, and we're already concerned about, claims, quote unquote, reverse racism claims. This thinking and the chilling effect is going to flow over into, for those of us who believe this is just about specific war forces, this is going to flow over to and flow down, deliberate word, with respect to MeBe contracting, 8A program. And not that the programs will go away, because the administration that's coming in is not going to support such an action, but they're going to become the subject of actions and claims. And so the government contractor community, for example, this RFI opportunity, one of the reasons you haven't seen real activity by individualized Fortune 500 entities, maybe in the same way that amicus briefs were filed in the context of Greta v. Bollinger, right? They're relying on the Chamber of Commerce to get involved with this. Why? If you go into an RFI situation and submit examples of your D&I activities, you may simply be engaging in informal discovery production for an investigatory claim to come back at you based upon the next, let's put it at least the next 60 days. So the government contractor community is already feeling this. There is a hope and a belief that, yes, you have a new administration that's going to come in and they will change things. But to be very candid, this is an issue to be aware of, even under the best of conditions, until, let's call it, October 1, 2021. Let me bring up another issue, because Mr. Drummer, Robert, I go way back, so it's great, thank you again for inviting me, I do a huge amount of work in the state and local space, right? State and local government contracting is, and that includes municipal contracting, is where lots of NBA clients generally, but particularly minority-owned clients, women-owned clients, do a lot of business. I want you to think about this hypothetical. Could you have a Governor DeSantis of Florida who takes this executive order, utilizes it as a basis to develop his own state level activities, and now work that could be done in city of Miami, Miami-Dade County, Fort Lauderdale, name your jurisdictions, that they're now subject to these searching examinations and the pretextual types of assertions that are made at the beginning of this executive order on the argument that they're just engaging in colorblind evaluation of programs. That is not an let's call it an untenable outcome. I should say an unlikely outcome. That is a real outcome. Pick your states, pick your municipalities. I had a colleague of mine, so I'll say something which I said off the top, but it applies to the same thing that Mr. Drummer said, right? The positions and perspectives that you're hearing from me reflect my individual analysis and not necessarily those of Accenture or its affiliates, including particularly Accenture Federal Services. That being said, having spoken to many people in the government contractor community, they will tell you that they are very concerned about what does this mean with procurements related to CARES Act funding, whether or not some of the subcontracting opportunities related to vaccine management and vaccine distribution may be threatened in terms of opportunities for our community. To what degree? So this is literally the type of discussion that's going on in the government contractor community. Could you see a circumstance where an analysis that is based upon science and medical outcomes that reflect our communities as being vulnerable communities, and therefore they should, because of the statistics, perhaps receive the vaccine a bit earlier, the vaccines at a bit earlier than other communities, again, because of science and impact, and that be challenged as being contrary to the concepts associated with this executive order. If you're a government contractor, you're shying away from that. I'm not even going to get involved in that discussion. I'm not going to put my POV involved, and I'm simply going to follow the decision-making recommendations coming down from this particular administration, which on the assumption that they get off of the election fraud, fantasy train, and they turn their attention to, let me put sand in the gears of the next administration. Well, they have 60 days to do that. That's enough time to do quite a bit. And this includes things like, and this is another perspective that's come up in the government contractor community. What does the pending question about a continuing resolution in the Congress to continue to run the government, that question, that decision day is coming up on December 12th. Does this, does this issue is as of tomorrow live? And it's arguably live for at least 60 days. And the after effects on government contractors could last 180 days or more thereafter. It's a live issue. And again, what happens in state capitals, where when you look at the outcomes of the elections, there wasn't a change in terms of POVs in those state capitals to a great extent, whereby contracting opportunities in that space, which actually have less oversight and are more subject to political machinations, those are real examples of what we're facing. So I want to emphasize a couple of things. I talked about the RFI. There is an RFI, but I think you're going to see most government contractors shy away from being active participants in that, and they're going to rely upon their advocacy organizations. It is interesting, relevant, and notable to see the U.S. Chamber of Commerce being on the same page as many of us on this call. I think that's relevant in terms of the absurdity of the order. Again, my individual perspective. I think you have to assume that, again, particularly for government contractors, they are priming up, firing up their in-house departments related to employment. If they haven't come to you, employment practitioners, they haven't come to you yet, they will be, about how to modify these trainings and modify these programs. And then that third, I'll leave it with, because I do want to make sure we have sufficient time, Robert, for Q&A, so I'll close it in this context. The cost elements. If you're going to adhere to these principles, or you are appropriately, effectively chilled by the implementation or the conversations that are going on around this, you may change your training program, not just the one that's internal to your organization specifically, but those that have been mandated or are expected as part of your efforts to comply with prior non-discriminatory viewpoints, that you change that program, you change your staffing. You change the cost of your contract, and now you have to put together a change order that you're going to send to the government to say, and often it will be through the change order process that you will, I'll put it this way, show fealty to the viewpoints that are referenced in this order to your government CO or COTR. The reality is that that's going to be a cost to the taxpayers, because you're going to increase the cost of your contract if no other reason than you need to change your staffing mix. So I hope that gives kind of an overview. I don't have slides. I just have the anecdotal and on the ground evidence of what's happening. But I think any of the other government contractors who are in practice can appreciate the threats and the weaknesses that we have to face, in the face of this order, and deal with government contracting is supposed to occur, and potential renewals or refunding or additional money coming through in the face of CARES Act, in the face of a potential continuing resolution related to the feds, federal government budgets, new budgets coming in at the state level, and the fact that the calendar year ends and maybe your contract is renewing, and do you get a COTR in this administration or a less than friendly state government capital coming to you and saying, I need to see that contract modified. All of those things are potentially on the table. I'll stop there. Hopefully it's perspectives. I could go on, but I want to make sure it's sufficient time for debate.
Thank you so much, Mr. Withers. And we will pivot to questions. We have a few in the queue. Before we do that, we'll provide the last and final code word and phrase for those of you who may want to apply for CLE. Keep hope alive. Keep hope alive. Not to include the boom shakalaka. So with that, we will turn to the first question from our attendees, which is, what type of disclaimer language might you suggest? It's been raised throughout about each of the panelists about disclaimers. We'll start with you, Mr. Withers, if you have any idea on in response to that question.
It was an excellent question, and I was actually trying to maybe type in some perspectives, but I'll tell you at the top line, there is no, I'll put it this way. It's very dependent, as often is the case, on your situation, on your subcontractor, and on how your contract is structured, right? So my first, and this is what everyone's doing, they're going to their OCs, they're going to their outside counsel. I would say that you're going to need to tailor your language in a way that reflects the current reality or the expected reality, let's call it over the next 6 months. It's probably going to end up in your change order in terms of either change orders or subcontractor flow down provisions. But here's what I'll tell you. The language that you create, you're going to need the input of your employment counsel as well as your government contractor counsel, which aren't always necessarily the one and the same. You're going to need government contractor counsel who helps develop contracts for you, but you're also going to need your compliance counsel, and you're going to need the input of your labor and employment counsel, because all of those areas are where they intersect. And you have to think about issues that, for example, if you want to be, let's say, a bit strong in your relationship with your subcontractor, you may engage in what amounts to I'm going to use the phrase wrongly, a cram down provision in that subcontract that says they pick up the cost of the change and you're not going to pick up the cost of the change. Now, you see what I've just described. I've actually created an appropriate prime sub dispute right there. But that is again, the nature, the recklessness with which this order has been released. It doesn't account, it's so agenda and ideologically driven. It's not thinking about the practical effects of how does this operate in the government contractor community. So now, to the degree you're a subcontractor, you may get language coming from your prime that you disagree with, that you yourself, in terms of your subcontractor environment, which maybe has less, shall we say, tolerance for thinner margins, to modify your structure, and your prime is going to ask you to take on the cost. You're just going to have to absorb that because they may or may not get that cost modification approved at the prime to client level. So I don't have any boilerplate disclaimer language because frankly, we in the government contractor community, we're developing it as it unfolds, right? We are waiting and seeing. We feel a bit less, put it this way, the temperature went down in the room with the election of Biden and Harris, but everyone understands that there still needs to be a game plan, and we're still mapping out that game plan. Again, it doesn't technically go live till tomorrow. Let's see what the month of December brings to us. I don't know if that answers the question, but that is the real POV.
Okay, as a follow-on question, you covered some of that, if not most of it, about model flow down language for subs and consultants. Before we move to the next question, I'd invite the other panelists, starting with Ms. Nelson. Do you have any reaction to that similar question?
Yeah, I guess two things I would add is just, you know, as we said at the outset, the terms of the order are so vague in so many ways that it's difficult to know what disclaimer language would sufficiently protect a contractor, a subcontractor, or a grantee. We know that, you know, as I tried to underscore, the phrase that speaks to the very subjective reaction someone may have to a training or may have to program content makes it really a free-for-all. And you see that is what that's the sort of division that this executive order intends to promote, because it created, you know, what we've termed a snitch line, this hotline for any employee or anyone who happens to witness a program to call and complain about it and say that they felt harmed or discriminated against or discomfort. I mean, it is truly so broad that it captures untold emotions that one might experience. The other thing is, I know that earlier, Ms. Withers talked about the idea that a state level law, even if this is rescinded, a state level law may come to replace it. And we're already seeing not exactly that, which I agree is a very accurate prediction, but there's already a lawsuit, at least one that I'm aware of, in the state of California, filed in the Superior Court of California, that makes a challenge on the same level to state agencies that says that, any programming that centers critical race theory or talks about systemic racism is a violation of civil rights laws and is in effect reverse discrimination. So we're starting to see this take form in various ways throughout the country at the non-federal level. So again, this will not go away just through the rescission of this executive order. Some of the damage has already been done, but a successful resolution against this order will hopefully have a chilling effect on these types of copycat efforts, which we think will continue to proliferate if not swatted back.
Okay, thank you. And lastly, with Ms. Wilcher, do you have anything to add in response to that question?
Actually, no, I think what's been said, especially about consulting with your, not only outside counsel, but labor and employment law counsel in particular, I think is well taken. I am impressed about the fact that this is going to the state and local level. I've been so focused on the federal level, it just didn't occur to me that this is going so broadly. We will continue to be fighting this. This may help us resolve what we're going to do as an association, because this is going to last longer than January. So we thank you for the information, but yeah, just consult outside counsel is all I can suggest.
Okay, thank you. Another question we have is, what are the protections, if any, on higher education institutions, for example, community colleges? We talked earlier about not only this executive order applying to federal government contractors, but also federal government grantees. Ms. Wilcher, would you like to take a stab at that?
Apart from the exception for educational institutions and the objective pedagogy, which again, the question is, what does it mean to be objective? I would urge, and half of our members work for colleges and universities. Again, we're going to have to work with our associations like ours, with counsel, because there isn't any real protection for them under this order. Many of colleges and universities are federal contractors or receive grants, so they all have to be concerned about the potential reach of this order. And so, again, we need to work with groups such as in LDF and ours and the legal community to protect ourselves from this order.
Thank you very much. Ms. Nelson, kind of along the same lines, we have a question from a city government attorney who asked whether it's required for local government entities to include provisions in federally assisted contracts. Can you speak to that?
I can try. One of the things that we have recognized in this order is that by its terms, the federal contractors are clearly targeted by the order, and as of tomorrow must include particular provisions in their contracts. That's for sure and for certain. Grantees and others with more attenuated relationships to the government are not clearly impacted in the same way. It's unclear as to whether the government will try to go after them or not, and I can't offer legal advice on that front, but I know that the order itself is specifically targeted to contractors. There's a request for information, as someone mentioned earlier, from other entities, but its application beyond federal contractors is still murky. And that is important because it leaves those other entities in a really sort of risky area where they can make the stance that it doesn't apply directly to them and keep engaging in the speech communications that they want to, and risk losing that funding, or they can take a more cautious approach. But a federally assisted program, in my mind, if it isn't directly, if the government does not come after that program at the moment, given enough time, I eventually think they will. That's clearly what this order ultimately hopes to do, and that is to control the speech of any entity that has any support from the federal government.
If I could add something here, under the executive order, 11246 executive order, and they're alleging that they're going to also do the investigations using 11246 as well. Federally assisted, at least in the construction area, is covered by, and is enforced by OFCCP. I don't know about non-construction, but again, it could reach. I mean, given the fact that they've also suggested that these kinds of programs may create a hostile environment, then they're assuming that Title VII, as well as 11246, would prohibit that kind of activity. So that tells me nobody is safe unless you have maybe fewer than 15 employees, because you're covered by Title VII. So they reach you one way or the other.
Okay, and our last question.
Mr. Drummer, this is Kendra Norwood, chair of the section. I just want to make note of the time. It is 1:30, so we probably need to go ahead and shut it down. I did want to thank each of the panelists. It's been a wonderful, wonderful panel, and I thank you so much for your time and your insights. And I noticed that we do have Madam President C.K. Hoffler on the line, and I wanted to, of course, give her an opportunity to close us out.
Well, thank you so much, Madam Chair, and to Robert Drummer. I'm forever double booked, but this is an issue that's near and dear to my heart. I do, part of my practice, in addition to catastrophic injury and commercial litigation, is employment discrimination. And this is probably about one of the most bizarre and disruptive executive orders that I've seen in a long time. So all we can say, I think it's Mr. Drummer that said, let's keep hope alive. Yeah, we need to keep hope alive, but we need to, one, get rid of this, and two, keep our eyes on the state, because we have to remember that and this is not a partisan statement, this is just a real statement, that over 70 million people may feel very strongly that this is something that is valid. So the struggle continues. We do need to be very vigilant. For those practitioners who are advising people, I think there's a lot of legislative and lobbying work that needs to be done on a statewide level to ensure that this type of an order and other similar state measures don't take on to dismantle the civil rights movement, because that's how I see it. I think these are very troubling times, and this is a very troubling executive order. And the only thing that we can say is state reality, which is Biden-Harris will be sworn in January. So thank you on behalf of the National Bar. This has been a great conversation, a much needed conversation, and I look forward to part 2.